So good evening all of you, and thank you for coming here. Before we begin with the session, I just wanted to take a couple of minutes of your time and introduce Moneylife Foundation and the work that we've done. So first of all, thank you all of you for being here on a Saturday. So Moneylife Foundation is a non-profit organization. Our primary focus is on financial literacy and financial advocacy and consumer advocacy. Through our seminars and through our training sessions, we have done a lot of work in the field of financial reforms. To date, we have done more than 435 sessions. Some of our speakers, as you've seen in the video, have been really high-profile bureaucrats and chief ministers and railway ministers, etc. of this country. So, other than that, we also do a lot of work on right to information through our RTI Center. Through that, we help people understand about the RTI Center, what is RTI, how to file RTIs, and we help them understand a little bit about that. So that's primarily what we've been doing for the past so many years. And incidentally, this February on 29th is our 10th anniversary, 10 years of Moneylife Foundation. So I just wanted to lend a personal invitation to all of you to come and join us for the anniversary. You can register here after the session is done as well. So without taking too much of time, I would like to invite Sucheta ma'am to introduce our guests for the day.
Before I do that, may I invite Jamshed Mistry and Mr. Kilachand onto the stage, please. Thank you so much, both of you, for agreeing to be part of this really important session, because I think any of us who have had anything to do with courts are worried about what happens, the outcome, the time, the money, and the fact that what is said in court is often not reflected in the order or the final decision. And it's a serious concern. In fact, over the years, many of us begin to say it's not just about justice delayed, it's justice denied, but the fact that there is no justice at all, because even access to justice is becoming more and more difficult for most people. So we have with us today Advocate Jamshed Mistry, who has filed innumerable public interest litigations. In fact, he's also got a record of being asked to be the amicus curiae, or what is called the friend of the court, I think the maximum number of times in the Bombay High Court. He practices both in the Bombay High Court as well as the Supreme Court, and more importantly, he is very keen on building alliances of lawyers across the world. So he's done a lot of work in Canada, and he is part of, in fact, he's the founding person behind Global Alliances of Lawyers, in Canada as well as, where else have you done it? In the UK as well, right? Correct. So, Jamshed works actively for social and medical legal cases, the rights of disabled. He's done a lot of work in Goa. He set up the Goa Action Plan, and he's done a lot of serious work on the business about hawking. He's worked with Sameer Zaveri on railway issues. In fact, he's one of the first people to take up this case, which was finally closed after 18 years, which has led to serious improvements in the manner in which people who fall off the trains are treated, the medical treatment that they get. He's a member of the legal committee of the Goa Chamber of Commerce and Industry, and he's had the Goa Law Commission in setting up an international arbitration center in Goa, and he's also a member of the Media and Information Communications Center in India. Mr. Amrish Kilachand is the more interesting person today, and unusual, because he comes from a very well-known business family. He is the litigant in the case that Jamshed took to the Supreme Court. Very rarely, as he correctly points out, it's very rarely that we hear the litigant speaking, but it requires a real passion to be able to go to the Supreme Court and say, I feel strongly enough about this that I'm taking this case to the Supreme Court, which is what he's done. And it turns out that this is not the only case that he's done. I just asked him why legal transcriptions. And like I think all of us who have ever been litigants, it is his dealing with a number of PILs. In fact, I want to hear a lot more about what he's done from him, which is going to be part of the talk, so I'm not going to babble too much about it. But his education is, he's from the University of Pennsylvania. His family business includes petrochemical trading. He represents some of the largest petrochemical companies in the world, including Amoco and Dow Chemicals and W.R. Grace. And he's had 15 years experience in Uttarakhand and extensive legal experience because of the number of cases and PILs that he's taken up, which include several precedent-setting judgments. With these few words, I'm going to hand over. The way it's going to happen today is both of them are going to talk about legal transcription. I think a few points that I need to make is that our neighboring countries are far ahead of us, including Pakistan, in the use of legal transcriptions. This is another area where we are lagging behind. It's very unfortunate now. Our growth rate is less than Bangladesh. But to think that even when it comes to legal transcriptions, Pakistan does better than us is pretty scandalous. I think we ought to get there. We have a Supreme Court judgment, and I think as you'll hear from Jamshed Mistry, we even have the roadmap of how it should be done because it has been mandated for people with disabilities. But typical of India, we have a lot of things on paper. We don't implement it. So today, the reason for even having a discussion is so that people are aware of the issues and that all of us join in to push for this, because it's very important for all of us to have a legal record of exactly what happens in the court, because there are serious consequences to the recording of what is said and what is argued by both sides not being there, especially when cases are half heard or there's a new judge that's appointed, hearings start all over again. I mean, I could go on, but anyone who's dealt with courts knows what a nightmare that is. So I think we should start with Jamshed. You're going to come, you'll show the videos first? Okay.
நீதிமன்ற விசாரணைகள் இப்படித்தான் இருக்கும் என்பதை பல்வேறு திரைப்படங்களில் பலர் அறிந்திருப்பார்கள். ஆனால் நீதிமன்ற வரலாற்றிலேயே முதன்முறையாக நீதிமன்ற விசாரணை அனைத்து தொலைக்காட்சிகளிலும் நேரடி ஒளிபரப்பு செய்யப்பட்டுள்ளது. ஏராளமான வழக்கு விசாரணைகள் சர்வசாதாரணமாக நடைபெற்று வரும் நிலையில் நேரடி ஒளிபரப்பு செய்யும் அளவிற்கு முக்கியத்துவம் பெற்ற வழக்கு என்ன? இப்பொழுது பார்க்கலாம்.
கட்டாய தலைக்கவசம் என்ற நீதிமன்ற உத்தரவை அவமதிக்கும் வகையில் தலைக்கவசம் அணிவதற்கு எதிராக மதுரை வழக்கறிஞர்கள் சங்கம் 12 தீர்மானங்களை நிறைவேற்றியதுடன் உயர்நீதிமன்ற மதுரை கிளையில் போராட்டங்களில் ஈடுபட்டனர். இது தொடர்பாக அச்சங்கத்தின் மதுரை வழக்கறிஞர் சங்க தலைவர் தர்மராஜ் மற்றும் செயலாளர் ராமசாமி ஆகியோர் மீது தொடுக்கப்பட்ட நீதிமன்ற அவமதிப்பு வழக்கு சென்னை உயர்நீதிமன்றத்தில் இன்று நேரடி ஒளிபரப்புடன் விசாரிக்கப்பட்டது.
நீங்க அந்த ரெசல்யூஷனை நீங்க தனிப்பட்ட முறையில் பண்ணலங்கிறீங்க. அப்படி சொல்றீங்களா? எப்படி சொல்றீங்க? ஆனா நீங்க எப்படி பிரசிடென்டா பண்ணீங்களா? நீங்க கைது போட்டீங்க. அதுக்கு உங்களுக்கு உடன்பாடு உண்டா இல்லையா? சொல்லுங்க, துணிவா சொல்லுங்க.
வழக்கறிஞர்கள் மீதான அவமதிப்பு வழக்கு நீதிபதிகள் தமிழ்வாணன், சி.டி. செல்வம் ஆகியோர் முன்பு விசாரணைக்கு வந்தது. விசாரணையின் போது உயர்நீதிமன்ற மதுரை கிளையை ஏன் சிறிது காலம் மூடக்கூடாது என வினவிய நீதிபதிகள் உயர்நீதிமன்ற தலைமை நீதிபதி வழக்கறிஞர்களுக்கான செயல்பாட்டு நெறிமுறைகளை உருவாக்க வேண்டும் என்று கூறினர்.
இந்த வழக்கு நீதிபதிகளுக்கும் வழக்கறிஞர்களுக்குமான வழக்கு அல்ல என்று பலமுறை கருத்து இந்த ஊடகங்கள் தவறாக சித்தரிக்கின்றன. ஏதோ நீதிபதிகளுக்கும் வழக்கறிஞர்களுக்கும் பிரச்சனை என்பது சித்தரிக்கின்ற சொன்னார்கள். ஆகவே இது நீதிபதிகளுக்கும் வழக்கறிஞருமான பிரச்சனை என்பதை தெளிவுபடுத்தியிருக்கிறார்கள். எனவே சுமூகமான சூழ்நிலை உருவாவதற்கான வாய்ப்பு இருக்கிறது.
விசாரணைக்கு பிறகு நீதிபதிகள் இருவரும் இருவேறு கருத்துக்களை தெரிவித்ததா தேதி குறிப்பிடப்படாமல் தலைமை நீதிபதி அமர்வு விசாரிக்க பரிந்துரை செய்யப்பட்டது.
மாண்புமிகு நீதியரசர் தமிழ்வாணன் அவர்கள் இந்த அவமதிப்பு வழக்கு ஒரு முழு அமர்வு விசாரிக்க வேண்டும். இது இன்று நேற்று நடக்கின்ற பிரச்சனை அல்ல. இது தலைவர் செயலாளர் மட்டும் இதற்கு பொறுப்பாக மாட்டார்கள். ஆகவே இந்த வழக்கை முழு அமர்வு விசாரணை செய்ய வேண்டும் என்று சொன்னார் என்று ஒரு உத்தரவு பிறப்பித்தார். அதற்கு மாண்புமிகு நீதியரசர் சி.டி. செல்வம் அவர்கள் முழு அமர்வு விசாரிக்க தேவையில்லை, இது இரு நபர்களை விசாரிக்கலாம் என்ற மாறுபட்ட கருத்தை அவர் பதிவு செய்தார்.
இந்த வழக்கை நீதிபதிகள் வேறு அமர்வுக்கு மாற்றுவது தொடர்பாகவும் தலைமை நீதிபதிக்கு பரிந்துரை செய்துள்ளனர். இரு நீதிபதிகளுக்கிடையே இந்த வழக்கை வேறு அமர்வுக்கு அனுப்புவதா இல்லையா என்பது குறித்து நீதிபதிய கருத்து வேறுபாடு ஏற்பட்டுள்ளதால் இந்த வழக்கின் விசாரணை 2 வாரத்துக்கு பிறகு என்ன முடிவெடுப்பது என்பது தெரிய வரும். புதிய தலைமுறைக்காக ஒளிப்பதிவாளர் சுரேந்தருடன் வி.எம். சுப்பையா.
Chief Justice, Justices, I want to focus my argument this morning on Section 15 of the Charter and its relationship to freedom of association as guaranteed by Section 2D. In oral argument yesterday, what is actually freedom of association has been unfairly or inaccurately described as discrimination. Whenever someone alleges discrimination, we must ask, by what standard? By what standard is the allegation of discrimination laid? And that standard must be found in law. The law will tell us whether we are dealing with discrimination on one hand or association on the other. And the Ontario Court of Appeal erred here. In paragraph 115, the court ruled that TWU's admission policy discriminates contrary to Section 15 of the Charter and Section 6 of the Human Rights Code. One would expect that a Section 15 analysis and a Human Rights Code analysis would either precede or follow such a bold legal conclusion. However, there is no such legal analysis in the judgment. And I respectfully submit that if the legal analysis had been done, the conclusion would have been different. TWU couldn't have discriminated contrary to Section 15 of the Charter because the Charter does not apply to TWU. And TWU does not discriminate contrary to the Human Rights Code because TWU actually benefits from special protections within that code. Those special protections are explicit protections of associational freedom, as this court has said repeatedly. Those protections enhance associational diversity. If I may, I'd like to play that out with two examples. Yesterday, we found out that the Chief Justice is opening a law school in her basement very soon. That law school is trending on Twitter right now. It's all the rage. So let's play with that example. Let's assume it's the McLaughlin School of Law for Women. Right? It's a private attempt to raise the profile of women in the legal profession and to enhance feminist scholarship in Canada. Now, is that association or is that discrimination against men like me? Well, a thorough legal analysis would reveal that this is association protected by Section 2D of the Charter and not contrary to Section 15, and in fact it's protected by exemptions in the Ontario Human Rights Code. A second example. If I told you that I'm imagining a law school that's going to start, but it has limited seats for people of color, the immediate reaction of the bench and every lawyer in this room would be a good one, and that would be, that's a bad thing. But what if I told you, well, that law school that I'm imagining is actually a law school that we're going to open in Northern Ontario, giving privilege to First Nations people to enhance the place of Aboriginals in the legal square here in Canada. That changes the equation. Is that discrimination against people of color, or is that association for the purpose and benefit of First Nations? In each of these examples, the law will tell us conclusively whether we are dealing with association or discrimination if we do the legal analysis. And I submit that TWU is analogous to the McLaughlin School of Law for Women and is analogous to the First Nations Law School. Furthermore, if the law societies were to reject the Law School for Women or the First Nations Law School because they would see it as being discriminatory or not based fully on merit, well, I submit that the law societies would then themselves be guilty of discrimination on the basis of sex and discrimination on the basis of race, just as they are currently guilty of discrimination on the basis of religious minorities, contrary to Section 15, as is the case before you today. The argument that Section 15 somehow compels the law societies to reject TWU, it twists the fundamental design of the Charter. That Charter is designed to be a shield to protect the freedom of non-governmental institutions. And to argue that Section 15 somehow compels the law societies to reject TWU reforges that shield into a sword to be wielded by the state against TWU. Our Constitution has been described as a living tree, but it is not a mutant organism. It does not have the ability to fundamentally change its essence. The Charter shields TWU. It does not, as this Court has said in TWU 2001 and in Andrews, the Charter does not impose Section 15 obligations on TWU. Subject to any questions, those are my submissions.
Thank you.
The reason why we played these two words, one is, I'm sorry, I thought it was Sri Lanka, it was Madurai, which is great. Let's focus on the second one first. The interesting bit about, you just had a look and you saw what happened in the Supreme Court of Canada in a particular case which had all the trappings. You had a young counsel who was extremely articulate. He was very, very sort of mindful of the time limit and what he said, and every word that he actually spoke is not only video recorded but also it is audio recorded. Okay, and that's the amazing bit. We'll come to that as we speak. But I just wanted to give you a sense of not what we see in our courts today and how a court and this is very normal. This is not something very exceptional. I mean, that little amusing example of if the Chief Justice started a school, things like that. So even there's a lot of sort of interplay with words and jocularism, and which is fine, even in courts abroad. So now let's come to the topic which we're really talking about. Okay, first and foremost, I'll just give you a little bit of a background. As Sucheta said, I went from here completely homegrown as an Indian lawyer, and fine, as standing counsel we like to stand. So that's fine. So in essence, I practice here from starting with the Labour Court and then the High Court and then the Supreme Court in several matters. And then one fine day in 2013 or 14, I was asked to appear for a particular matter in the Supreme Court of British Columbia, which is equivalent to our High Court. We were also called, if you remember, the Supreme Court of Bombay, which is many years ago, before independence. Now, it was very interesting that one went into a courtroom very, very quiet, like how the Supreme Court in India was many years ago, very quiet place, extremely plush. That's another, you think you're entering a 5-star hotel. And then you had the judge. The judges over there wear red gowns, so it's quite, the counsel or the barristers, they wear much thicker sort of gowns and with the upturned collars than we. I mean, they look more like our judges in that sense. They dress up like that. And here I was wearing an Indian coat, Indian band, and Indian gown, and we have some lawyers here, so we know how. And the beauty about our gowns are they were very light. So everybody was asking, where did you get this from? I said, no, I am from India. So and then the case happened. Now, in this particular case, the applicant or the accused, this was basically where this particular gentleman of Indian origin was accused of an 800-year-old law saying that you had committed contempt of the Supreme Court of British Columbia. And there was no case law that was available at all in Canada. So this guy started looking for lawyers in Canada. He started, unfortunately he couldn't get anybody because they had never done something like that. Then he started looking outside because they follow the common law system. The Queen of England is still the head of their state. So he started going out. So he spoke to Nelson Mandela's lawyer. He spoke to Julius Assange, British solicitor, that is Mr. Mark Stevens. And then he spoke to this little thumb of Tom Thumb, Jamshed Mistry, saying that, can you help me? When I heard Mark Stevens' name, it's like, when you hear, so I said, you mean Mark Stevens will actually be present in court? So he said, yes. I said, fantastic, I'm on. I didn't know what it was all about, but I said, let's go ahead and do that. Very interestingly, I mean, this is again something very interesting. We were able to do all our research sitting in India. Okay, we have Canadian, just as you have the precedents, the All India reporters, etc. We were able to get all that. I request if anybody wants to, you have the Bombay High Court website. A lot of international case law is available there. It's a great place to look at. So we did all the research and we sent it to him. If you remember, many years ago, the Contempt of Courts Act in 2005 was actually amended to include truth and public interest as a defense. I remember how difficult it was to get something like that on our statute book. We did it in India. So I said, we have that, the background. So why don't we use that also and show it as comparative law in Canada itself? So when the case actually came on, and what did I notice? So you had the judge, you had the reader or the associate sitting down, you had this gentleman who was appearing on his own, who said, I need the assistance of a counsel from a Commonwealth country, and then you had the Crown or the government counsels on that side. The judge was of Caucasian descent. The associate was Chinese. This gentleman was a Sikh, and the other two. And here I was from Mumbai, India. We argued the matter. It went on for about a couple of hours during the day, and we came out. We stepped out. All was fine. And in the evening, he comes, the client comes and gives me something. I'll just show it to you. Sorry, I brought it. Something like this. So he says, I said, what is this? He says, this is the transcript. I said, I see. I said, I have never seen something like this before. Can I have a look? He said, sure. Now, typically, this is the name of the case, the parties. There is an index. It is outsourced to a private body. So the court has actually outsourced it. And then you have the entire proceedings verbatim, including a dash. There's a dash. Everything. So what I argue, or what happened and transpired in court on 17th of September 2014 at a particular time to a particular time is recorded. Okay. So this is one. What is interesting is, okay, every single, so I said, this is great, this is fantastic, I said, you mean you get this for, every single case? He said, yes. If you are, in certain cases you apply for it. In criminal cases, and if a person is not of sufficient means, it is free of cost, it's given to you, say as legal aid. The same client then said, I am coming to India. I said, come. So he came, he got bail, and he flew with me to India, and I had a matter in the High Court, and he came and he saw what happened. And he said, but where's the transcript? He said, who's this? There was this person who's sitting next to the judge, writing something, but how come I don't see the timer, I don't see. So I said, my friend, there is no transcription here. So we were, we were like, diametric, like North and South Pole, and trying to talk to each other about this. I was quite apologetic to him, saying that, listen, but he said, listen, you are a common law system. Why don't you have transcript? And what do you do? I met for example, in British Columbia, what we call, for example, the Advocate General or the Attorney General, and it was a lady at that point of time. The Attorney General and Law Minister over there is one and the same person. So it's a great thing. So she asked me, she said, we were having a chat, and she said, what can we do to collaborate and things like that. I said, you know what, in India there is no transcription. So she said, what? She said, how do you appeal a judgment? I said, we appeal the judgment only on the basis of what the judge puts together and says that, well, this is what he thinks is the law. So, there was a complete shock. We said, okay, fair enough. Now, let's go back to 2 years ago. Our senior advocate, Mrs. Indira Jaising, they filed this petition, in fact, a couple of petitions, on the whole issue about live streaming. I immediately called her up and I said, you know what, I said, this is great. I'm very happy that you filed it. But I said, there is one area that we are missing, and that is legal transcription. I said, suppose if the Supreme Court says no live streaming, then what happens? He said, no, you're right. And that's when I spoke to my school friend actually, Amrish Kilachand, and I said, you know what, I said, you've seen what it is like abroad, etc. Why don't we intervene? So he said, it's a great idea and we should do it. So we intervened in the about 3 or 4 petitions. One was the law students and a couple of others who had filed. And we argued. And we said that, yes, we completely support live streaming, but apart from that, if we must have legal transcription and the 3 judges, Chief Justice, Justice Kanvilkar and Justice Chandrachud, not only allowed our applications, but said that this must be done. So, great. So, on the same day that the Adv judgment, September 2018, the courts have now said that yes, transcription is necessary. Now, let's go back again in the point of time. I started researching during that period of time. I said, surely if this is a common law or something that has come down from the British, I mean, it must have been there somewhere, sometime. I spoke to a lot of people. For example, Mr. Rajan Jaikar, advocate, who's helped in setting up the museums in the Bombay High Court, and of course earlier in the Supreme Court. I spoke to people like him, I've spoken to others. They said, no, we've not found anything like this. Then out of curiosity, I was researching, I came across a famous Tilak's judgment, Bal Gangadhar Tilak, in 1908. And there was the order was passed by the then Justice Dawar, and lo and behold, after reading the judgment, I think you should read the judgment anyway to see how polite they were, for example. Okay, and then finally, after paragraph number 27 onwards, I found what I was looking for. It was one of those eureka moments. There was transcription. It was transcribed. So if in 1908 we had transcription, what has happened and what have we actually missed in this entire period of time? It is all conjecture, I don't know, but I think probably what may have happened is, because we got rid of the jury system, along with that, and it became more judge based, this very important aspect went out. Then we started looking at other systems. We said, why not look at, because we found that the legislature, for example, also uses it. Everything, they used to use stenographers. They used to change stenographers every 10 to 15 minutes over a period of time. Now, with technology, you have the, Rajya Sabha, Lok Sabha TVs live. Every sort of proceeding of your assembly and the parliament is recorded verbatim. So surely there is now, we have not only technology, but we have people. One great thing about our systems is, and I have to give it to them, is our stenographers. I'm sure some of you may have actually dealt with them. They're amazing. You even as lawyers, I remember even as a junior lawyer, he would say, okay, you dictate the facts. So you dictate it, he would take it all down, all in shorthand. And then what would he do? He would transcribe it. Some of them were so good that he said, okay, I don't even want to know. You tell me, it's a writ of mandamus, no? Okay, fine. The draft would come with writ of mandamus, prayers, this, that. Amazing. I mean, hats off to them. So even they used to start at 20 rupees, and some of the senior stenographers in those days, 50 rupees per page. Oh my God, But so we have this group of people who can actually be trained and in transcription. Now, what does transcription actually entail? So of course, I believe technology is such that you can go straight from speaking here to like a direct printout. That's possible. But in law, like for example medical transcription also, you need a human interface. Now, suppose our judge suddenly says, yes, Mr. Radhakrishnan, there's a problem. So he will sit down and ensure that the correct name, the correct pronunciation, everything is done. This then gives, okay, so what is the real benefit of this, of legal transcription? Number one, as you saw over there, everything is crystal clear. You can play it, repeat it as time and time again. You can read this again and again. You know what the lawyer, the judge, the witness, everybody said. So there's no escape for anybody. So it's complete transparency, number one. The second aspect is, okay, quite often the media reports things in the way the journalist understands what has happened in court. Very often you can't even hear. Why journalists, even we as lawyers, we can't hear. I mean, Samir is here. How many times we used to confer that what did he say? I mean, we are not persons with disability, but we still can't hear. That's one. So, internationally, for example, the Supreme Court of UK, okay, not only is the order that is appealed against, of course, it is transcribed. Even the judgment, the day the judgment is pronounced, that is transcribed. And the other important aspect is they come out with a press release saying that this is what we actually mean. They just make it simple for everybody else. The other important aspect, which we have a problem sometimes, the judges don't sit on time. Even that will get resolved because there is a watch and a clock saying that so-and-so has sat at so-and-so time. No difficulty at all. Okay. So this has brought, and in today's age with technology available, I mean, let's be honest, as Indians we are everywhere. Google, everything is owned by us. I mean, at least the technology, the acumen is all ours. Why not something like this? Okay, and it also eases off. I'll give you two examples where I have actually told the judges that why can't we have transcription. One was I was appointed amicus in one was at the Kalagoda, whether to allow Kalagoda or not. And I remember at a very crucial juncture, I had a surgery in I think December 2014 it was, and I just missed that whole 1 week. So, the petitioner's lawyer was saying something, the newspapers were saying something, my junior colleague who was there in court was saying a third thing. Now, who do you believe? The judge must have said something else. Who is going to capture all that? And is it possible? The answer is, at that particular point of time, it was not possible. So I went to court, and I said that I think it would be great if we had transcription. They looked at us. Second one was our famous potholes matter, again, where I was, the honorable judge had written a note in 2013. By the time I was appointed, it was 2016. There was papers this much to the ceiling. Even as an amicus to assist the court, and what would the order sheet say? Matter heard on so and so, stand over to so and so. That's it. So I'm supposed to read all this, and after that, everybody else has been there from the beginning, but I am disadvantaged, and then I have to come and assist the court. So you can imagine, these are a couple of examples. How many times we've seen that court cases for admission are heard again and again and again. Benches change. Why can't we have, so and so say, oh, but that was said before another bench. We don't know, we were not there. Hello? This is, let's be honest. Anywhere in the world, this particular aspect can easily be taken care of. It's systematic. There is no problem. The cost to the court is not going to be that much, and it will completely change. And the other important thing is people will stop shouting in court. People will maintain it, as you saw on that particular the Canadian court, a very strict timeline. 15 minutes. You should see how. Please have a look at other cases also. The barristers there profusely apologize if they're even overshot by a minute. It's amazing. And I think all these, it will just make things, and importantly, you will get all your backlog will get can be cleared. There will be complete, because we all say there is no transparency. There is no, in one easy resolvable, understandable method, you will be able to see a huge change in the way, not only from the citizen's perspective, but from the lawyer's perspective, and importantly from the judges and the media. I think all the factions can actually have a much better and a more easier sort of relationship, and there won't be any problem in that. I will end with just one particular example. We had a particular case where a particular bench, this lawyer was arguing. We had actually intervened. This happened in the Bombay High Court not so long ago, and the judge turns around and says, this is not properly drafted. So he says, okay, allow me to withdraw this particular case. We all understood across the board that he has given him liberty to withdraw the case. And in the evening, which now has become a habit, we try and check the online orders. So very often, and since Samir is here, we used to exchange. Samir, have you got it? If not, send it to me. What the order said was, petition dismissed as withdrawn. All applications dismissed. You, sirs, and respected madams, you decide, is that correct or is that wrong? We hope legal transcription can change all this. Thank you so much.
Thank you so much, Jamshed, for an excellent presentation. I think now we need to hear the other side, because when we went to court the first time, I'm sure it happened to you, the first shock is that you can't even hear what the judge is saying, let alone what your own lawyers are saying. So may I request you to tell us how we got to this?
Okay, well, thank you for having me here. Normally people always speak Judges speak, lawyers speak, but it's very rare that a litigant will come across and speak about all the problems that he faces. And strangely enough, he's the one who is driving the whole system anyway. Right? He's the one who's paying the court fees, he's the one who's paying the counsel fees, he's running the whole establishment. Okay? And yet, his voice is not heard at all in all this. Right? He's always considered whatever. So, I thought I can address this from a litigant's perspective because I've spent more than 22 years in various courts, from the lowest courts to the Supreme Court, across states. I've done a lot of PILs, I've done a lot of RTI, a lot of litigation with BMC, the police, various departments. And when you spend over 20 years and as a litigant, you attend court and you see what goes on, you start getting a perspective that everything's in complete chaos. Okay, first of all, in our country. I mean, that's the first thing you see. The whole system is chock-a-block. I mean, today it's reached the stage to get a date you have to mention before a judge. Please give me a date. Okay. Or there's an urgency or whatever these issues are. So it's come to this situation and normally we find it very easy to blame the judge. Okay, because he's the fall guy. He's useless, he's this, he's that, he's whatever, But what we don't realize is that, the judges today are taking home over 100 matters every day. Yeah. He sits from 10:30 to 5:30 in court, okay, going through the previous day's matters. You send him home with 100 matters. He's got to go home, he's got a family, he's got to allocate his time, his resources, whatever. He's up to here with work. Okay. So now what happens is, naturally, he will have to choose out of those 100 cases which ones he's going to hear, whichever the top. So he creates his board. Okay, he decides these top 10. So now what does that do? It typically limits it to a normal human reaction. Okay, whoever is the biggest counsels appearing or whichever the biggest cases on board, I think I'll listen to them. Whoever, big companies, big corporates, people, whatever. And, you have this other concept. So now he's already chock-a-block. He's going to find it impossible to hear so many cases. He gives lawyers 5 minutes, 10 minutes time in which that person who may come with that many papers, but he has to make his point across to the judge. Okay. Now, there are various dynamics that come into play, okay, in this court system between all the stakeholders. So a litigant comes in when he's got a problem in life, whatever be the problem, personal, corporate, whatever. When he comes into the system, he's coming into a system where he's entering a lawyer's world, which is where the lawyer is going to be making his fees of this case and whatever else is coming his way, right? So now you've got a little bit of a cross-purpose dynamic because the lawyer doesn't want the case to end, right? Because it's probably determining his fees, and the client wants his justice as soon as possible because he's paying for all this money and he's in trouble and he's got all these issues. So, what typically happens is in this system today, you file a case, right? You think you're going to go and get a hearing, you're not going to get a hearing. Okay? Because if you go there for a certain purpose, the counsel on the other side is equally well trained to thwart all this. He'll ask for time, he'll ask for dates. When he realizes that this is not working, he'll file interim motions to stall litigation, chamber summons, motions, always take 10 years to come up. Okay? So now all your litigation, the main litigation is gone. Okay? You never hear of final hearing suits today. How many people have you heard, I'm going for a final hearing? You never hear it. Because this whole, by the time the final hearing comes up, most people are already, unfortunately passed on. They're not even around. So, they're not there. So, what's the point of having this system? Okay, when everywhere you move along, it doesn't end. Right? There is no end. It just continues, and the prayers in your final suit and your motions are the same. So, by the time these things come around, there's complete chaos, right? And now the other problem is continuity, right? So now I file my suit, it's come before Judge X. Judge X hears me 10 minutes, say the arguments continue, right? And the opponent lawyer stands up and he starts arguing on something, and then, of course, there's not enough time, so the judge says, okay, I'll hear it another time, or something, or whatever, or they ask time. Now, the matter gets knocked off the board. Now, knocked off the board is another major problem because to get it back on the board, back before the judge, when there are 150 cases on his board every day, is another whole mission. Now, next time the hearing comes after a few months, okay, if at all, And what happens? The judge has changed. Right? So now the other counsel is going to stand up and you're going to repeat your argument and he's going to stand up and say, I didn't say that. Right? I didn't say that. Or I said this, not that. Or this. Now, you can't blame the judge. He has no record in front of him to know what's been said before or not. Counsels are changing all the time. Right? That's another problem. Today I bring ex-counsel, I realize, I need to change. He comes and says something totally different in court. And the whole litigation goes off on a different tangent. But what is there for mainly is not being addressed. Okay, and these are all strategies. I mean, lawyers use this all the time, and also the question comes down to, in all this, where is the delivery of justice? Okay, 10 minutes, if at all, no continuity. People come with whatever their life's work of papers and whatever, and one-line orders, matters are dismissed or things, and that's it. And who do you blame? There is the system itself has become so congested, okay, today, that you can't blame anybody. I mean, it's just chaotic. So what is the solution? How do you get past all this? Right? Government of India is the largest litigant today. Okay, I would say probably 50% of the litigations are frivolous litigations, okay, if not more. Today, I know the BMC wants to throw me out. I go and file a suit in court. Because I know next 20 years they'll be... this is the strategy people use today. They're using the courts to deliver injustice. It's in fact spun the other way around. Right? Many litigants do that. To stall proceedings. I've say someone's taken some money, property, whatever, someone else says, I move the court today. It suits that person to keep it going for 20 years. That means he is indirectly misusing the court and its system to ensure that I don't get justice, or whoever else. It's not me, it's whoever the litigants are. So in all this system, right, and what does it come down to? It comes down to that time in court, right, which is the interface between the judge and the lawyer on behalf of the litigant. What is spoken there, okay, many times litigants don't even attend matters, so they don't even know what's going on, okay, and these statements are being changed, everything's being changed. I have seen undertakings being given orally in court, which the next time the court says, oh no, I didn't give any undertaking, right. So this is the system today. You see the Supreme Court today. I mean, the Supreme Court, I don't know how many of you all have had applications or moved before the Supreme Court. However big your matter is, whatever it is, you get 2 minutes. Okay. In 2 minutes, you have to convince that bench that your case is worthy of hearing ahead. Now, when you've got, by the time you reach the Supreme Court, you've gone through already heavy litigation. You've gone through it from the lower courts, you've got paperwork, you've got judgments, counter judgments, everything. By the time it reaches, you get 2 minutes. So how would there be justice? It's not that there's anything wrong with the judges or anything, it's just that the system is overburdened. You cannot expect them to deliver judgment. I mean, when there are 150, 200 matters on the Supreme Court judges' benches, you should see those lists. And on top of that, in the beginning, people come to mention matters, and then you have all this going on. So there is just complete chaos. So that judge himself is in a situation, what's to be done? He's firefighting all the time, right? Because he has no choice. So then we come down to the other issues. So India is on this great, we want to become a world superpower and we want to be a great place to invest in. Would people really invest if your system or your judiciary is in this state of affairs? Right? This is being, all lawyers and the institution is being asked this question, because today companies come in, they want justice, they want it fast, because obviously they've got lots at stake, there are lots of things happening around them. People, will this system work? It will not work. They will have to change it. And more importantly, within India, there is a huge change coming about within the legal system. Judges, as you saw, the Chennai bench, are asking for this. Because even lawyers, judges know that this will make their life much easier. Okay. You've got the Gujarat High Court monitoring the lower courts today, okay, via video. So these systems are coming into place. Everyone is pushing. Delhi High Court is almost, I would say, over 50% digitized. Everything goes into archives. These archives are permanent records. They cannot be changed. Okay. So now I'll come back to the transcription part. So what was that one thing that I saw that is required if you needed to change the system completely? Partial changing is not going to help, because again you'll come back to this gridlock. It's like, in the middle of a road you build a bridge thinking, I built a flyover, but it comes back to the end of the road and you're back into the same traffic jam, right? So that won't work. The moment you have transcription, as Jamshed mentioned, the first thing you will bring is transparency, right? There will be transparency in the system. Counsels will be restrained by their choice of words. There will be no more blind and statements, random statements made, because it's all recorded. And it opens up the door to perjury, right? Because if you lie and it's recorded, you've got even more trouble. So the first thing you will do, okay, is you will curtail this problem of lawyers going in all directions. And at the end of the day, the client can see what his lawyer has argued for him, which I think is very important, because at the end of the day, you have to know what his words are. Has he understood what I'm trying to tell him? He's got 50 matters himself, the lawyer. I mean, we blame judges. What about lawyers? All big counsel. Have you seen the amount of files they have? I mean, do you really think he's reading all those files? He's not reading it. It's not possible for him to read it. It's physically not possible, right? Without reading. No, without reading. As counsels come to court without reading also, I've seen. So what happens? It's easy for them. It's their profession. But what about a litigant? This is his life. I mean, he's filing litigations for a certain reason, right? He's not just there. This is not his profession. I can promise you he doesn't want to be here. Okay. But he's here because he has no choice.
He is forced to.
He is forced to go there, right? So, this is another thing that transcription do. It will restrain lawyers. The other thing for litigants, one of the big things transcription will do for litigants is it will remove frivolous litigation. This whole concept of, hey, this guy is acting for whatever, I'll file a suit against him, I'll do this, I'll fix him, I'll do all these things, it'll all end. Okay, but again, it comes down to everything is being recorded, and those records are archived on a daily basis. You cannot change that statement. So if a counsel has said X, he's bound to stick by X, right? So the next day, if new counsels come, new judges come, new whoever comes, that statement continues. What it does is, it makes it very easy for judges. Based on transcripts and the law, he can pass judgments without having to look at even the matter, because what's being argued in front of him is what's important. So, and then you have a case, your suit should be brought down to what I call the notice of motions. You come down, you have that hearing, it's done and over with there and then. There is no further hearings. Your case gets dismissed then. Whatever the issues are, you finish it then. Why should it prolong it? Okay, there are some exceptions in tax, other issues where you may need it, but that should be an exception, not the norm. Today has become the norm. Okay, and then the other problem is this appeal process that we have, which I think is in a way pathetic, because once you cross the lower court, now you're going into the Supreme Court, where you have this 2-minute system. And then see, the Supreme Court was not designed to be an appeal court. The Supreme Court is a court of law to test your constitutional matters, the test of law. But today what's happening, everyone under the guise of test of law goes and appeals in Supreme Court. I lost in the lower court, I went to Supreme Court. So you're putting burdens, and in fact I personally think the Supreme Court should become a lot more strict about this. That look, you come here, we are going to fine you, we are going to deter you, we are going to make you pay if you're coming in to do wrong.
Yes.
Right? Because the litigant also should be held responsible, why not? At the same time, so all should be held responsible. The whole issue is that every stakeholder, and the way he'll become is through transcription, because now everything is recorded. So, civil litigation is all, okay, what about criminal litigation? Okay, what about under trials in our country? Okay. There are lakhs of people languishing in the jails in India who are not tried. They're just sitting. If you have been to criminal courts, a van will come with 50 people. Okay. These people have lost their human, they've become numbers. Yeah. He comes, he stands, he gives his attendance, and he turns around and goes. Okay, the judge doesn't have the time, because there are 50 here, plus there are about 200 applications around him. So what does he do? Attendance is given, they're taken back. So now these guys are languishing. Okay, they're just languishing without being told they're guilty or free, whatever. They're just languishing for years on end. Okay, transcription will end all this, because then it will come down to the gist. What is the matter? What is the crime in X amount of days? Disposed of, and it's end of the matter. There is nothing ahead of it. Okay. So this is another area where I think transcription is absolutely mandatory in the criminal justice system, because it's in complete chaos today. And you hear this about so many innocent people who are languishing in prisons just because they don't have the money to afford a good lawyer or whatever their problems are. But this is the reality of the situation. The other issue that where transcription will help is, what about differently abled people? Are they not entitled to the same justice we are? Should they not know what is being spoken in a court of law if they can't make it there? They should know. They should know each and every other proceedings. So this is where I think for differently able people also, it's a perfect mechanism, right? People who have vision problems or have hearing problems, you can do so many different things with it. But at least they know today that they have justice, right? And what is being spoken in court, they're able to interface with and understand and respond to, which today they can't do. As he says, you can't even hear what's being said in front. I mean, if we find it so difficult, imagine differently able people how difficult they find it, right? If they have to go into a litigation. They also litigate, I'm sure. So that's another area which would benefit hugely from this transcription that. And transcription is not the beginning and end of all. In my opinion, it will solve probably 80% of the problems. But there are still other fundamental problems which I'll just touch upon to give you an idea of how we can even resolve that, right? So today what happens in a suit is, if I want to thwart a suit or if I want to cause trouble, I find chamber summons. I say, he didn't give me the paper. What paper? That's not relevant. Whether it even exists is not relevant. He's not giving me a paper. I moved a chamber summons. Judge is placed it for hearing. I've got my time that I wanted. I'm sitting back. And this chamber summons, by the time it gets heard, the main suit, nobody even knows what's going to happen to that, right? So coming back to it, I think this transcription, I lost my train of thought. Yeah, sorry, 80%. So the balance 20% in my opinion will come this way. In England, okay, the system that they follow, so suppose you've got a problem, Mr. X and Y are fighting. So what will happen is, you've already reached a stage where you're exchanging letters by lawyers. Both sides know the lawyers, or if they don't know, they'll soon come to know them. So what they do there is, all the lawyers, they have mailboxes, right? So if I'm filing a suit against another person, my lawyer will go and put it in the mailbox of that lawyer. So now he's alerted. We exchange correspondence. It goes to, say we go ahead with the suit, right? It goes to a pre-registry stage, which would be probably the registrar, protonotary, whatever. All your what we call tutu meme, he didn't give me this paper, this is missing, that is missing, that everything is sorted out in that office of the protonotary and master registry. All these problems, where then the case is prepared for the final hearing, and there is no reason for any more delays. I mean, all the everything is cleared out, right? Once you've cleared it out, the matter is listed on X day. That X day, that judge has 10 to 15 matters max. On that day, that matter will be heard and an order will be passed unless there is a death in the family or there is something very, very serious. No dates are given, order will be passed on that day, end of story. Case closed and it's over with. This is what I think we need to bring in apart from transcription. If we add this one component where the registry should take care of all these issues which stall litigation unnecessarily, then the judge's life is also limited to just hearing the matter. And if we can get a judge to dispose 10 to 15 matters every day properly hearing, and your frivolous litigation drops, and all the other issues drop because of transparency, of transcription, what you will see is the whole system will clean itself up automatically. All these issues that people say, corruption of judges, corruption of lawyers, corruption of litigants, it all disappears because everything is recorded. What are you going to be? Everything that is said is recorded there. There is no more room given for all these things that happen today, which is all Ram Bharose. Everything is Ram Bharose. It's all, there is just nothing. I mean, literally there is no continuity means there is just no justice. How can you have a justice system when everything around you is spinning except the litigant? Right? The judges are spinning, they're changing. The lawyers are spinning, they're changing. The system, but the litigant is standing there only, not knowing what to do. Because he's caught in that system. So, what I would recommend is, all of you people who are litigants and who are also lawyers, you all must start pushing using the Supreme Court judgment for transcription of your cases. As more and more applications come in, the courts will be bound to take steps towards this direction, and they're already orders of the Supreme Court, so there's no reason why they should not take it. Only problem is, it's still causing uncomfort. Anything new is going to cause, discomfort. So, of course, the judge is also a little wary, everyone's a little wary, but once they get into it, they will themselves realize that there is nothing better that our country needs than this, because this will, in my opinion, iron out all these issues that we have on a daily basis. So from a litigant's perspective, I thought I'll share some of my experiences and trials that I've had to take and what I think should be done. And one last point is, even for RTI, I think they should start transcription there too. Why not? Because in RTI, again, it's like this only, Ram Bharose. I mean, I've fought in the CIC myself. I've appeared in RTI right up to the CIC myself. Like that only. Everything is based on discriminatory issues, right? There's nothing recorded. So, even in RTI you should get it. If transcription is there in RTI, even that will clean up on its own. Because what the public information officer is saying, if it's recorded there, imagine the change that it will make. He will also be careful with what he's saying and recording, because it's all recorded. This is the whole thing. Once it's all recorded, everything changes, I think. And so, this is what I came here to talk to you all about, and thank you for giving me the chance.
Thank you so much, Mr. Kilachand. I think everybody is very glad at the lucid manner in which you explain what happens in court, and I think all of us go through it. I don't think Jamshed expected you to expose the legal community so much. But I think both sides have been very informative. Can I start with the first question? Where are we at now after the Supreme Court judgment? There was one talk about live streaming, so how close or far are we away from transcription?
So I think as far as, in my limited understanding, and we always are very careful, but I think typically what has happened is Supreme Court itself, it has a budget, it has to sort of, start, because not only that, it has to frame rules first. There are issues about, for example, copyright of whatever has been is allowed to say live stream. So from what we understood was there was going to be an experiment. They were going to show. In fact, I think Madura has done far better than the Supreme Court. So they need to start that off. Now, what we need to understand is, if there is live streaming, there's automatically transcription, because the audio gets recorded. So I think we are very, very close. I've been talking to people in the Ministry of Justice as well. I've been asking them how far have you, if you remember, even for the Article 370, there were an application. There's several applications pending here before the Bombay High Court in several matters. For example, in this, the Scheduled Caste, Scheduled Tribe, the tribunal under the Atrocities Act and things like that, can it be used for is video recording permitted or not? I think there was a conflict. One particular judge said that yes, it can, and the other said no. I have went, and the other thing is, we presume that people know, and I say this across the board. There are a lot of people, including officers who represent the government, etc., who are just not aware. I mean, nobody has seen things like this. So it's very important that we try and explain to them, go and meet them, talk to them, and explain how important it really is. And as Amrish said, this is not rocket science. This is something that's easily available. So I think we will see this across as far, not only live streaming but even transcription. I think they just have to make a start. The other aspect that in fact we didn't speak about was for commercial arbitration. You know how expensive it is to fly down transcribers, because for your international arbitration centers worldwide, they insist. They're very clear. They said, you want anything to be done, it has, the proceedings must be transcribed. They will not compromise on that. So that's again an area where it is extremely important that the Indian system can actually be evolved We must, like how you have an ISI standard, we must evolve our own standards in as far as transcription is concerned. So it's interesting. There is a course that is actually available online today for transcription in Canada, and I've actually asked my junior colleague to go ahead and do it. I said, just go ahead and do it and come back and share your experience. I think whenever she finishes, maybe we can have another session like this and she can actually explain how easy or difficult it is to become a transcriber. So I think yes, we will see. The other area where I think it must be introduced is in law schools. Our future generations of lawyers, all who are extremely tech savvy, they are not going to take the nonsense that my friend Amrish has taken or some of you have taken. They're going to say, no, we want to see the change, and we know everything. What is it called? Thermonomics or something. It's all there. And I think we definitely, but we don't even need to wait till they, qualify and all that. We have to keep our efforts on. Yeah. For example, we can use it in moot courts very easily. There are easy, Google and other transcribing facilities which are available, and I think it should be, just as they said in the third year LLB, now mediation is going to be compulsory. Introduce transcription and live streaming. Let our next generation be absolutely ready for, and see the double benefit. If anybody goes to a court abroad, unlike me who was, like in shock and awe of the system, these people won't. They'll be, very happy, and that whole sort of batch of law students will be absolutely up to date internationally. I think that is the standard that we should look at.
I have two questions. One is, you said that we have to ask for transcription of our case. Is it not to be a system that for all cases it is there? Is
No,
it
of
that
course
you have
it
to
is.
go and ask?
Well, you're right, it is. It is become law, but the problem is in India, enforcement is always a little bit of a problem. So
Nobody can do it.
they need to, it has to come from the Supreme Court, and now that they've taken active interest and they've passed such a judgment, I think they need to set the mandate and choose certain courts. Okay, like say you take one CJM court, and you take one High Court and one, say, Supreme Court, and maybe in different forums, and limit it to 10 courts and start to see what comes out. But unless they don't do that, they are not going to know. Even it's very easy to sit and analyze and do, but the reality is, it's only when you jump into it will you understand the problems and solutions and everything else that comes with it. So they need, it's in their hands, and we are pushing as hard as we can, but we are one amongst
You said it is anyway being practiced in other
countries. Absolutely,
So
absolutely.
there should be no problem really.
Absolutely. In fact, the Chief Justice who heard the matter seemed to be reasonably well informed about the system in Canada. He himself referred to it and spoke about it. So they are aware of it. The whole question is, when it comes to implementing a system like this in India, when it is such a large system, I don't know whether the Supreme Court needs to do this. Does the Ministry of Law and Justice needs to put in some inputs to do this? I don't know who's the final decision maker.
There is one more thing. What about the Roznama which is supposed to be there?
Yeah.
The Roznama is supposed to list out what happened that day.
Yeah.
Is the Roznama not maintained?
Have you ever seen a Roznama?
That's what I'm asking. Isn't it mandatory that the Roznama should list out, what the two parties said or whatever it is?
For my understanding is that if a judge actually went down to list all this in a Roznama, imagine how many hearings, you wouldn't have any hearings only at the end of the day. It would be very difficult for, if you've seen Roznamas, they have 3 lines,
Yeah. So they
4
just say
lines.
who appeared, that's all.
That's it. They don't talk about the merits of the case or what statements are being made by each counsel. That's not been spoken about, which is where the crux is.
So why I ask this question is because we do this RERA conciliation. There we are given the Roznama to fill up. And what happens, what you said is that the Roznama is only filled who are present and all that. But at least we follow a practice of writing down, saying that what was at least discussed in brief, so that we remember, what happened.
I actually know some judges in the criminal side who actually maintain diaries. Like when they've got very high profile big cases going on, they maintain their own diaries for their own knowledge to keep that continuity going so that they're able to refer it to later. So you have judges who do this in their private, not private, their diaries left behind for the next judge. It's not that
personal capacity.
And he leaves it for the next judge for that matter, because if there's some, especially in criminal. So, I mean, it's only one more stage that they need to cross.
So I think you're right. Rojnama usually is the sort of the official standard of exactly sort of what is transpired, but it is not the true and complete picture of what has happened in court. I think that is what we are saying, that here is a process by which the entire picture is available to all stakeholders, one shot, and technology has now proven it. It is, happened in, in poor and rich nations across the world. It is a standard, and I just don't see why. I mean, we've just missed it. I mean, it's one of those things that we missed. But now I think it's. Can you imagine if you had your matter right from those days, the important, the public interest litigations of the 70s and all that, if everything was transcribed? How wonderful it would be, even for legal knowledge. I mean, we would all have understood who said, what were their, what was the sort of the arguments in court and back and forth, and how did the judge actually come to a particular conclusion. I mean, wonderful.
We all are agree that technology is helpful. And the Rodnama, I have checked on Sessions Court website, the Maharashtra District Court website is there. So Rodnama is there, and I spoke with that court staff. So they have to write it limited one, I think 150. So at least we can understand what happened on days. The accused absent, application filed for adjournment or reply given, cross-examination done, partly heard, etc. etc. So as a we individual citizen or the party of that case can go through the sequence by sitting at home on computer. However, the MM court, Metropolitan Magistrate Court, like at Mulund Court and other courts, small courts, I will check. When we click on that date, Rodnama according to Rodnama. There is nothing on website. Then you have to file certified copy application if you are party and you are really interested to know. Then you have to go to court, file application. So system is there. But Sessions Court up to okay. But nothing for the MM court.
So, very interesting. We've spoken to all sorts of people, including retired judges. Okay, they, some of them have this, because you mentioned a word called perjury. My God, I'll be sort of, if I say something, and let's be honest, some of them do use words which can be quite harsh once in a while. I mean, it's their style, it's their manner of speaking, whatever it is. But I think what it will do, and it's very important, it will bring in that immediate aspect of discipline. And nobody will then, and it's a great, but a very comfortable, okay, the other interesting thing is you don't feel like today, okay, I'm sitting here, I may feel that yes, you see, I'm being recorded. Maybe. I am being recorded. Yeah. So I am being recorded. So absolutely.
Psychology.
Wonderful. So if one is being recorded, then
And live streamed.
Beautiful. So that's even better. I think that's you should take over the running of the courts. But does that really change? Or we've spoken to lawyers in other countries as well. Has that really sort of changed an attitude in the way in which the presentation Of course it has. It has made them very, very specific, I think, in what they want to say. And that is the biggest plus, at least as far as the lawyers are concerned. I think that they're very, very clear. You can't use, sort of bombastic or extraordinary language all the time. I mean, I think that's out. Be clear, be precise, time limits, stop. And I think that is what, and has it also sort of, changed, like for example, the contrary thing is that you will be then presenting as though you're presenting, to a gallery. Initially, we may have some problems. People might play to the gallery. That's fine. But I think all that and more has been, been there, done that internationally. They have been through all those phases, and the resultant is, for example, what you saw just now. It's amazing. A very young lawyer who's addressed the court so crisply, so precisely, 5 minutes, bang, that's it. So I think from the legal perspective, it's a great move in the right direction. Sorry, I mean I must be the only person saying that, but that's what it is. There's someone?
Yeah. Hello.
Go ahead.
Yes. Sir, in the marketing right now, the people use the chatbot. Whatever you want, you just have to type and the machine will answer you. So this gentleman has said that, if at the stage of registration, if the artificial intelligence has been used, you submit your documents, you submit your initial statement, and put it in the register, and the judge back on the backside will be artificial intelligence who was fed with all the laws of the various things, and then it will judge what type of case is it, and then on the lower level of the judgments and things will be done by the artificial intelligence, and when it goes up to that, then in the human intervene will happen. So is it possible?
I mean, I'm sure that it is possible to a great extent. See, artificial intelligence, this is my personal feeling, that artificial intelligence and all these things to aid and assist the judiciary, to aid and assist. Like for example, today, yes, e-filing is one aspect. You hardly see in a court today, and I say this, why isn't there a laptop or a computer where I want to look at this particular judgment, immediately have a look, read it online. I mean, why are we even shying away? Why must we, environment and other, use so much paper? I mean, that's...
It will remove the emotions of human emotions.
Can you just wait for the mic because we're recording it, so if you want to speak something, I can give you the mic. Just one second.
Yes.
You said that there is a problem of the emotions. People sometimes they use a harsh word, sometimes they soft words, and this thing, that thing. So that type of human emotions also can be removed if on the back of it, it's a machine is there, it's judging it.
No, I think, at the end of the day, I mean, if for example, the lawyer has to be removed from the system, maybe you are right. But I think till we are there, and what is the difference? For example, I'll just give you an interesting example between the systems that we have here, and I mean I have great regard and great respect for the lawyers outside. One of the biggest differences is that today lawyers were, despite the legal education, despite all the weaknesses in our system, the lawyers in India, from India, are people who can think on their feet. You go to a court, you ask them a question which is slightly off. Suddenly, a judge says, no, answer me on this particular point. They go very strictly by the book. Okay? So this human part of it is in my understanding a very important aspect. Okay, I'll give you a small example on that. We may be digressing a little bit, but for example, if in a particular case, a disability related issue, the court once said, for example, you have the Commissioner of Disabilities is supposed to take suo motu cognizance of and sort of in case he finds that some disabled person has been wronged. Somebody goes to the Disability Commissioner, he passes an order, the order is not being implemented, so he comes to the High Court. The judge turns around and says, no, I have held that this Disability Commissioner doesn't have any powers. Now, somebody would have turned around and said, oh, the court has said that, then you are right, end of story. He said, no, I am here before you, I am here in writ petition. If the judge didn't have the powers, or the Disability Commissioner didn't have the powers to pass it, you as the High Court under Article 226, 227 have the power. Now, this is the human interface of, or the experience of a lawyer. You can change that instantly and bring justice to a disabled person. And I think that is a very important aspect in the whole equation. The aspect is to get to justice and get there quick.
We have the mic here. Just one second.
Sir, just thanks for the session. Just a couple of questions.
Sir, hold the mic.
Yeah, just a couple of questions. The first is, the big issue in what you showed was translation. So there are several courts which do in their regional languages, and then the translation of those transcripts needs to go to the upper courts. The other part is, there is already people who are doing live tweeting. Can that be used as a part of this?
Yeah, okay. You're right. The first, I think now the Madhya Pradesh High Court has introduced that all certified copies, and all that will be. See, what is happening is it's happening piecemeal, but it's happening, and we are very happy about it. Things like, so I think yes, you will find, just as you have apps which translate languages, here also that problem about sending it to official translation department. I mean, Amrish will give you many examples where we sort of some of the Hindi is so
artificial intelligence could help.
Yeah, it could help. Sure,
That's exactly where artificial intelligence could help and things like that.
Certainly. But for example, the Hindi or the Marathi is so particular that even the translator has a problem with it sometimes. But anyway, your second one was live tweeting. So you see, that is a step. In fact, there has been, if you remember, when some of the journalists started, reporting from court, and they would be sending, messages, because everybody is interested in knowing what is going on in court. So they were sending these messages out, and that was then getting translated, including on television channels. Well, you see, this is what is happening. Didn't you hear, for example, in Ayodhya, we are getting reports. This is what the court said. This is what. How are they getting that? They are obviously sending messages out. Now, is that technically very, very, I mean, that's a step. That certainly is a step. But it can also mean it is subject to a person's understanding and clarity on what the judge said, which the reporter, if you've seen a courtroom, first and foremost, it's packed in these very heavy and high stake matters, where a reporter sitting at one end, he may get something in mind, or he may be constantly asking a lawyer, listen, what did he say, what did he say? It happens a lot. You're standing in front of him, what did he say? Okay, so that happened. The other thing is, you have litigants, okay, who have gone ahead and used their phones to record. Again, I think it's a question of if all these things were implemented. I mean, courts have, some of them have fined. Aurangabad bench has just now fined a medical doctor 50,000 rupees for recording. Now, I think the judiciary must understand that the method of recording needs to change. But these are all in the interim. People have become, so desperate to get things done. So you have these sort of, issues. But I think again, the minute it is done, then where's the question? It is available for all. And when you say it is an open court, it is a court of record, you must have this.
So I think this live tweeting is very important because it started with the Aadhaar hearings. They went on for days together, and I think there some lawyers in the Supreme Court were doing the live tweeting, and there was an attempt to stop it. But I have a feeling that judges are humans, so they like the fact that tens of thousands of people are following every word that was being said and asked. So I said, I think technology is going to act like a disruptor over there, because now live tweeting is not only accepted, so every important issue, whether it was Ayodhya or the privacy judgment, was live tweeted by 2 or 3. And Aadhaar was brilliant because the lawyers like Prasanna did such a fantastic job. All of us were, I remember tweeting that it was like watching a cricket match, and we were listening to every word of it because it was being tweeted and done correctly. The point that you were making is so important because we can't hear the judges and the lawyers in our own cases in a high court, but they were tweeting absolutely correctly. I don't know how it's working, but I now find that Bar and Bench and Live Law and others are also, almost live tweeting judgments. So that is surely going to become a disruptor, right? Because it's going to be taken as given that people are going to report these judgments and what is being said in court, and it's just going to be then a matter of time before the judges sort of cave in and say, okay, do it officially.
Exactly. Wouldn't it be better to have a transcript at the end of the day with the correct facts
or
for everyone to see?
Or even live. Why not live stream?
Well, yeah, exactly. Why not? I mean, they should. You have Lok Sabha TV who are live streaming your Lok Sabha and Rajya Sabha proceedings. Why not the courts? They should have a Supreme Court TV.
I would like to know, what about the PRO? Normally in these courts, you have to move from pillar to post for any clarification, and various departments also are unable to give. So what do you suggest? Shouldn't there be a PRO at least?
I think it's okay.
No,
PRO's job is anyway to communicate. I don't think what you are asking is a PRO.
Guidance and administer whatever.
Yes, I think you will see over a period of time that them dealing with the media may actually come up with a position like that. I mean, that's they have administration, they have so many, and maybe they do need, like for example, an international judgment or a Supreme Court of the UK, they have an entire analysis of what the court said, and this is what the court feels, and they come up with a press release. Now, in India, no court comes up with a press release except in one or two interesting matters.
Good evening, everybody. First of all, thank you, Cheta and Moneylife. This is a very unique session where not only are we having a lawyer on the stage, but Mr. Kilachand, I believe I've come here as a litigant. I absolutely echo everything that you said, sir. And my cases are in the small causes court. And after 2 years, I'm a defendant. Okay, I'm not a litigant. I'm a defendant. After 2 years, the opposite party is asked for a stay, an injunction. 2 साल से सिर्फ बात ही हो रही है. So I told the judge on the last week itself. I said, sir, I'm wondering. I'm a chartered accountant by profession. We work by strict deadlines.
Sure.
There are time barring assessments. So after the court was over with all the matters, I just requested the judge, very honorable, nice man. This is the 4th judge in the last 2 years. Okay, 4th judge in the last 2 years in small causes court, Mumbai. I requested him, sir. I mean, I'm a chartered accountant. I'm surprised how your system works here, because And everything he said, I believe he echoed all my sentiments. What Mr. Kilachand said, he echoed my sentiments. It pained me. And I told him, sir, I want to finish off the matter. लिया दिया कुछ नहीं, ग्लास तोड़ा हाथ है ना, मुझे निकलना है सिस्टम से बाहर और मुझे आउट करो सर. So he was perplexed, and he didn't know what to say because he was sitting on the dais. But then he told me, I mean, since it was the end of the day around 5:40 or so he said, come next time with your lawyer. I said, sir, I can't afford my lawyer anymore because I've done it for 2 years. I'm sorry, I can't afford it. I would like to argue my case. I'm a defendant. I can argue better than my lawyer. Yes. But sorry, no offense to my legal friends here. I see something which he said, and probably I'll take it a bit further. And probably Jamshed also said that, do we want the lawyers out of the system? And very important, as he said, we have to filter it out at the lower stage. Okay. Number two, as a chartered accountant, I'm sure there's also one other very important thing that is being said here. I'm fighting as a reformist in the Institute of Chartered Accountants of India, along with 30 people. We don't get replies to RTI. There are tweets on Twitter which say that the Institute of Chartered Accountants of India secretary is putting a tweet, a letter, which is tweeted by the applicant of the RTI. I cannot give you the information because the department head has not given me the information. There are cases against past presidents of the institute which are being fought in
Well,
I'm not digressing, but at the same time, transcription.
The information officer will get punished in this case.
Yeah.
He doesn't reply.
But, well, technically, legally, what you're saying is right, but how long can a litigant go on fighting? I'm sorry, but transcription and live tweeting, I believe, will probably help.
Absolutely.
The 80% you said may not be 80, it may be 70 or 55, but at least it will take us further. And continuity of matters has to be maintained. And the last thing you said was, it really hit me. The whole system is spinning except the litigant is still there. I think that takes the whole session, in my opinion. Everybody it's revolving. And I saw a movie, the end of the movie, it's Article 375. I do a lot of work for the film industry. I normally don't watch films. I do only my work with my clients. But Article 375 is a very nice movie of Bhumi Pendey. I would suggest all of you to see it. The last 5 minutes, it says all about our system. It caps it. The system is not here to deliver you justice, no. The system is here for being in perpetuity and continuance of business. I think it sums it up. Thank you very much for the opportunity. I'm sorry if I have digressed. I'm sorry.
A very small question. We are all talking about legal transcription. But in the courts we had seen there are a lot of, huge files and bunch of files and papers being submitted to the court. What happens to that? How that will be taken care in the transcription?
No, those. So I think if you have a look at what they've introduced in Delhi, for example, is going to be an e-filing system. So it starts, and I believe it's going to be so good that you can actually, from your own computer, you can e-file your matter directly. So you cut out this whole issue of paper. I think that it's a matter of training. It's a matter of getting, I think a lot more needs to be done. We understand that today the judiciary is in a particular, but their training academies, for example, like, do you remember those days where when computers first came in, all of us had to go and learn at NIIT and other institutions like that. I think the time has come. So you have to now learn. If it has to be done electronically, then fair enough. And I think we are used to it. Technology makes things easier. We spend so much time on our phone. Everything is now. We can really get rid of paperless system. We just have to say, like, you have a particular, say, sorry, I'm using this phrase, cut-off phase for slum rehabilitation, right? Similarly, you must have a cut-off phase that from this day onwards everything should be e-file finished. That will be the end of paper. And there are more than you can certainly keep a backup in paper, but I mean, what is the problem? Today you have video conferencing, you have people give testimonies from all around the world. If a document has to be shown, it can be shown. The veracity or otherwise can easily be found. So we are heading in that direction, no doubt about it.
And just to add, one of the things I see that our court system needs desperately is digitizing of their own records. I mean, this is something that they don't do themselves, which they need to do. Can you imagine each and every will, whoever has gone to court to probate a will, okay, the original is lying in Bombay High Court. For how many years are we going back? All the originals are sitting there. Okay, because that's the place of record. Now the question is, if you want to take out your grandfather's will or your father's will, you're not going to get it because it's somewhere in some attic lying, because they need to change this. All these records of the court need to be digitized and stamped and then destroyed. They don't need to keep the originals. Today the problem is keeping originals is a problem. Once you have everything digitized and stamped, right, and then what they do in England again, they charge money. Right? So if you want to go and take out a probate or a suit of 20 years ago, they are going to charge you a lot of money for that, because that's how they also earn their fees, and it's a deterrent to anyone to just collect anything. But this is how they do it there. Everything must be digitized. Why not? I mean, who wants to go to the effort of, I'm telling you, I've had lawyers complaining, I can't find, original documents of 15 years in the courts. They've disappeared in the system. You go and ask the court clerks who work there. Okay. He said, "Sir, attic dekho hamara." They're like, they get scared to go. You go to the public prosecutor's office. I don't know how many of you have been there, but you go and see it. There are papers stacked from down to the wall, running across corridors. Okay. Forget the fire hazard and all. But the reality is, why don't they just get some agencies and digitize all these documents and eliminate everything? You don't need to keep these documents anymore, and then you never have to fear about losing them once they're permanently recorded, right? So I think that's one more thing that's required, is digitizing of records.
Yeah, I request to give view of both of you about just Aurangabad bench imposed the penalty of 50,000 rupees to one doctor for recording the court proceeding. So I have 3 points. One, the Supreme Court is in favor for the audio and video recording of the court proceeding. In foreign country, it is already there. Second, our parliament, there is the live TV. Any citizen or across the world, anybody can see the parliament proceeding, and it is also audio video recorded. And also, Criminal Procedure Code, the section 327, under a 60 year, there is the provision that criminal court is open for public. Anybody can go and sit. And our eye is also 6 megapixel lens, and our brain is also natural recording system. So, what is the behind to impose a penalty 50,000 to the doctor?
I honestly think that including this particular judgment, it's ignorance of the law. I don't think this was ever shown to the judge or explained to him, because it must have happened we can only imagine. Now again, imagine if that was transcribed. Okay, you would have known exactly why he has imposed something like this. Okay, so you would have got that. And I think the Adv judgment came out on the same day. I don't think that did complete justice to our live streaming matter. I think that is another, I think that's again why, people must know it. They said, okay, theek hai, hua, and then what? Because you haven't seen, implementation for such a long while. But I think you're absolutely right that there's no need, for example, if somebody's cell phone rings, okay, you confiscate it, keep it, put an end to it. And these days, you must have seen in that particular court, the cop actually goes around and checks that, please put off your phone, etc. So I think there are simple and effective methods to get it done. By and large, our citizens are not, they're God-fearing, they're court-fearing also. So they won't do it. But you have some people who, for reasons best, are ignorant, and therefore they don't know, and they think that this is the only thing that they can do. And therefore, and it's an old system. The system is that you cannot record what is happening in court. I think that luckily under Article 32, Supreme Court has broken that myth. And a beautiful phrase, sunshine is the best disinfectant. So I think that's the answer.
I just want one clarity regarding the public screening and the transcription part. Because the public screening can be done, in case of maybe PILs or cases which are, the class cases, which will be applicable to the whole society and all that. But individual cases, I think will the public screening be there, because that people may not like, the privacy issue comes in.
Correct. So if you read the judgment, that's what they say, that you will start with important cases, okay, as far as live streaming is concerned, and then they said we hope that this will, they've actually asked the high courts to frame their own rules and go ahead with. Also, there are restrictions. There are no two ways about it. Even internationally, there are restrictions. So that's a given. I mean, I would. In fact, I'll send you a little article that I have done, and maybe that will help. As far as transcription is concerned, that's the beauty. There is no such problem, because there is no. I mean, in the absence of live streaming, okay. Suppose there is only transcription. Then what happens? Then there is only audio recording, and it is done in a particular way, and it is completely in control of the court. Nobody else. So that is also important. It is with them. So and now you have technology. I mean, it's amazing. You should actually see. I'm talking now. I stop. It's like you get a printout. You say, you said this 2 minutes ago, right or wrong? There's no dispute, no debate, end of story.
And it's being tweaked now for all the regional languages, because otherwise we have this problem of the translations taking place. But I think now they've managed to cross that.
Very easy.
Yeah, it's no issue at all. So.
We have a few legal students also here, so some of you, if you wish to ask any questions.
Hello sir, I am in the final year of law. I have just given a paper on interpretation of statutes. I want to ask a small question related to that, because you told us that the transcripts can be transcribed and recorded verbatim. So suppose if anyone wants to interpret it, so how will they be interpreted? And the second thing is, how will the appeals be filed? Because if anything is taken verbatim, and if the judge comments on something, if that has been taken into consideration and the appeal has been filed, so how will the court proceeding work?
So you have to understand that a transcript is the record of proceedings that have happened, right? Now I am talking to you. I mean, suppose I am arguing. My lord, in case of so and so versus so and so, or section so and so says this, I am arguing. So that gets recorded. So that the judge will, instead of him making notes, it is all there. It is an automatic. He will reflect upon that, and then he will pass his judgment. So this will help. It will definitely help in filing an appeal. I'll give you one of the best examples. In a matter that I had done here, where there was no transcription, nothing. In a motor accident claim matter, okay, the other side, we were for the accident victim. The insurance company came in appeal to the High Court, okay, and their lawyer had argued on a particular issue, saying that this was not considered by the court. Unfortunately for him, in his written submissions, which were annexed to his petition, I pointed out, I said, see, this was already mentioned by him in his written arguments. So the judge said, there you go. and the insurance company's petition was dismissed on the ground, the fact that you have actually taken that ground in before the lower court. I'm telling you in a scenario where there is no transcription. But when it is there, of course it makes a lot of difference. It is a something, and it aids and abets what you actually say in court. It's a complete description of what is transpired in court. So the question of interpretation of statute is very different. When you interpret a statute, you are actually looking at the law.
So my only question was, can every statement of the judge can be appealed whenever you file an appeal? Whatever is in the transcript, he writes down in the judgment. Whatever he has mentioned in the transcript, can every statement be put up in the appeal? So he has taken so and so comments. Whether those comments can be interpreted by the lawyer.
You can certainly use it to your advantage. You have to see what you appeal against. You don't appeal against the transcript. You appeal against the judgment. Right? So whatever judgment he or she passes, you then appeal against that, but you can certainly refer to saying that, this is what they meant, this is what was argued, this was what was said. And I think it gives the bench or the appeal court a much better view of what exactly transpired in the lower court.
I think we are done, so we've taken enough questions, so we've got to maintain the time limit also.
I think we've had a really wonderful and very enlightening session. I think there's pin drop silence from everybody, as you can see, hearing what you had to say. So thank you, both of you, for the time that you spent. We have a small little memento, a little book that I'm sure both Jamshed and Mr. Kilachand will be fascinated with. May I request Mr. A.V. Shenoy to present a copy to Jamshed Mistry. And I'm going to request Walter Vieira, our trustee, to present a copy to Mr. Kilachand.
Thank you.
So thank you once again, and let's give them a big hand for this great session.